Nobody wants to listen to me. That's fine. And I said, you want to do all that? I'll let you do it. You don't know what you're supposed to be doing?
I know what I'm not supposed to be doing.
Okay. No. Yeah. Where is she?
It's 11.
From where? This was set at 9.
Yes, sir.
Okay, so that's it for that block.
Yes.
We'll call it up. Ms. Henderson, we'll get to you. We'll get you.
Definitely. And she said that she emailed the court. She tried to call the court.
I know. She called the clerk's office. She emailed the court. She's still not here.
Because it was. So I gave it.
Okay. All right. Court is standing in recess.
Sorry to the staff, the prosecutor, my client, Nicole Sadi. I represent Ms. Henderson. She's present today, standing right next to me.
State your name.
Nicole Henderson.
Thank you. All right. What are we doing?
I had a chance to go through the discovery. I know that Mr. Cook had worried that one of the videos wouldn't play. All of the digital media plays for me. Having said that, I was looking to see if there were specifics regarding the actual testing on the body-worn camera, but I don't have that covered. So I'm going to be requesting some more information from the prosecutor's office after viewing the video regarding the testing methods. I understand there's no offer on the table.
Testing.
The blood testing. I also wanted to clarify, Your Honor, I believe the court asked probation to go ahead and run an intake for my client through sobriety court at 14 time. I wanted to confirm.
I don't know that I don't have a referral. Ms. Lundy, you know anything about additional evidence regarding the testing?
I do not, Your Honor. I'm terribly sorry. I wasn't entirely clear what defense counsel meant, so I'm not sure what the request is for.
So when I did my research, I was looking at MCL 333-16215, the qualification of the person drawing the blood. I was also looking at, it looks as if the administrative rule, it's ACR 325.2675 rules blood testing. And the case law, and I was going to write this up for Mr. Cook. The case law shows that we have to look at the time it was taken, which identified body, whether it was an authorized licensed doctor or a med tech or RN.
All of that's in the police report, isn't it? Who drew?
I don't believe so.
Your Honor, I'm looking at the police report. This is Pittsfield Township Police Report 26-7981. And I will also, for the record, note that I'm standing in today unexpectedly, so I apologize for not having more familiarity than I have right now. But it does say that the police officer arrived with the defendant at Trinity Health at 0048 hours. There was a delay, and then when the blood draw was done, it was conducted by a nurse. The nurse is named under the direction of a doctor who was also named. The blood kit is given with a lot number. I am very familiar with the administrative rules, and I'm very familiar with the blood testing requirements for OWI cases. And I think that there does appear to be a lot of information within this report. So, not sure.
Could you please, and I may have missed those particular items, but I was just going through the rule myself. Could you please tell me which page number you're on in the report?
It's under the section marked blood draw, page 10.
This exchange is more important than it may seem at first. The defense is not merely challenging the blood test result. They're questioning whether the prosecution can establish the proper legal foundation required for that evidence to be admitted in court. In an OWI case involving a blood draw, The reliability of the testing process is just as critical as the numerical blood alcohol result itself. Notice how Judge Simpson repeatedly asks defense counsel one key practical question. What specific information are you actually missing? That is a strategic move, intended to distinguish a genuine discovery concern from a speculative objection. Meanwhile, the substitute prosecutor redirects the discussion to the existing evidence, pointing out that the police report already identifies the nurse who performed the blood draw, the supervising physician, and the collection procedures. By doing so, the prosecution shifts the focus away from broad legal arguments and back to the documented facts already contained in the case file. Defense counsel responds carefully, avoiding any claim that a legal violation has already occurred. Instead, counsel explains that additional review is necessary before determining whether there is a valid basis to challenge the evidence. This measured approach helps preserve credibility while leaving the door open for future objections if further investigation uncovers a legitimate issue. What do you think? Does this cautious strategy make the defense appear more credible, or would a more detailed and specific request have been more convincing to the judge?
I do have a name, so I will correct my earlier statement. I had seen nurse, but I have names in what would be the second full paragraph on that page. Yes, I do have the lot number. That is correct. When I was looking through the admin rules and the list that I have, I'm looking at a couple of different things: method and procedure for transport, methods for conducting tests. At the same time, we do want Ms. Henderson to do an intake with the sobriety court. So I don't want...
Have I resolved whatever your discovery issue is?
I don't think so. I'm going to put in a written request, Your Honor.
Okay, but what's the written request for?
Well, when I'm looking at the case law, I have a total of 9 elements that are supposed to be used. Whether it was properly preserved or kept, the method and procedure for transport, the method and for conducting tests. I don't mind giving you the case that I took this from. It is...
I'm very familiar with the cases involving that. What, though, are you asking from the people? Because I'm not going to have you come with a motion saying they're not complying with something.
Well, I'm actually looking for information on whether or not it was complied with. I understand MSP uses gas chromatography, but it looks like the actual transport of the blood is one of the factors under the case law from when it was taken forward to the testing agency, to Michigan State Police. I guess that would go along with what we think of as chain of custody. The properly preserved and kept is actually separate here than the method used for transport. So there's more information to be had there. So I don't know that I do have a challenge yet. From what I'm reading, this information needs to be supplied, and then there I can tell if I have a challenge.
And Your Honor, like in every OWI case I've ever seen with the blood draw, the laboratory report from the Michigan State Police indicates the date that the item was received, the date that the report was completed, the date that the report was released. It also, the Pittsfield Township Police Department Public Safety Report also indicates that the items were sent to the Michigan State Police. From a quick review of this case, there doesn't appear to be anything missing that I can see at a quick glance, nor does there appear to be anything exceptional or strange. I know the court's familiar with the preservative within the tubes for the OWI blood draws, and that preserves the blood samples, so they do not need to be refrigerated, and they can be transported in the United States mail. That's an acceptable way to transport blood samples. So it appears that everything that I can see looks good here, but if there are specific requests that can be sent offline and addressed not during the docket, I'm sure Mr. Cook would be happy to look at those.
I do have a specific request I'd like to put in, Mr. Cook.
The hearing gradually shifts from debating evidence to assessing risk, and that distinction is more significant than it first appears. Once the discovery issue is deferred for written motions, Judge Simpson turns his attention to bond compliance and whether the defendant has shown enough responsibility to warrant additional privileges. From a legal standpoint, the travel request is not about whether the defendant deserves a holiday. Instead, it is about whether the court believes she can be trusted to comply with the conditions of her bond while outside the court's immediate supervision. Notice the prosecutor's response. Rather than objecting outright, the prosecutor asks about the defendant's current alcohol monitoring. That question is far from incidental. If continuous scram monitoring remains in place and the defendant has consistently complied with its requirements, the prosecution has much less basis to argue that temporary travel presents an unreasonable risk to public safety. Judge Simpson is balancing several competing interests at once: rehabilitation, accountability, and the protection of the public. That is precisely the purpose of bond supervision, to manage risk while encouraging compliance and progress. Another subtle but important detail is the defendant's willingness to discuss treatment programs rather than resist them. The judge appears to view that as a sign of accountability and genuine engagement, not simply an attempt to avoid consequences. Did you notice how the discussion gradually became less about punishment and more about whether the defendant was sincerely committed to recovery? That shift often has a greater impact on discretionary judicial decisions than many viewers realize.
Turn it to August 5th, 2026, 9 a.m., or as your invite indicates.
Father, I did have a question regarding your court procedure. I don't know if that's something you would like to do off the record or on the record.
Oh, no, everything we're going to do on the record.
Okay.
What is it?
My client is requesting to go out of town for one weekend in August. She has provided me with some travel plans. I would like to go ahead and put in that motion. I don't know if Your Honor would receive it informally through an email if you would like me to file a formal motion with the court.
Trying to go.
It's a Christian travel retreat in Atlanta. She would be at a Hilton at 255 Cortlandt Street in Northeast in Atlanta, Georgia, from August 14th to August 16th.
People have any objection?
Your Honor, what is the current testing order for Ms. Henderson? I know that she was released, and I know the court knows that she's got a significant alcohol history, so I just wonder what her testing is right now.
She is currently on a scram tether. I can see it from here.
Excellent. I don't have that advantage, Your Honor. As long as she remains on the tether and she remains compliant from now until the dates of her travel, I have no objection.
All right. And that was August, what date?
The 14th through the 16th.
And have you gotten yourself enrolled in non-farm?
So I have intake with my job tomorrow at 8 a.m. And
You have what?
the intake with my IOP
Okay.
tomorrow at 8 a.m. So even though Don Farms was my idea, I was going to ask, can I renege on that? Like, that's a lot. So,
What is the lie?
because through my job, it's 3 times a week for 3 hours. And then Don Farms, they said it was in person. I know you said that.
I did. Nobody wants to listen to me. That's fine. I said, you want to do all that? I'll let you do it. That's all right. So your intake for the resources through GMUAW is
8 a.m.
tomorrow, 8 a.m. tomorrow morning. Okay. And that's Atlanta.
Yes.
The 14th through 16th, that includes your travel.
Yes, that's Friday through Sunday.
Is mom going with you?
Yes.
Is she going with you?
No,
I don't know. She let you out on your own. Oh, okay. All right. Well, all right. Here's what I'm going to do. Provided the defendant is compliant with her bond requirements and enrolled in her IOP, then I will permit her to be able to travel to Atlanta, Georgia, August 14th through the 16th. Yeah.
Could I also have a copy of my bond requirements? I didn't get it right on the journal. Can I have it printed out?
You don't know. You don't know.
No, I know. I know.
You don't know what you're supposed to be doing.
I know what I'm not supposed to do.
Okay. All right. Sometimes that's as good as anything, right? Okay. Well, your bond, yeah, you can get a copy of your bond requirements up at the front. The things that I added on release is that there was a scram tether prior to your release, and I put rolling Dawn Farm and GM employee program. Not going to have you do both because now you understand why I was. Yeah, I know what you were trying to do. You were trying to do anything you could to get yourself out. I hope, and the way I took it really was your acknowledgement that you have a problem that you have to address, right? And you're willing. I took it in a good way because I think what you're trying to do is do anything and everything you could to try to address it. So, all right. So I'll allow that travel. I'll take that one condition of Dawn Farm out. All right. But if for whatever reason the IOP isn't working out for you, you still have that as an option.
Okay.
Okay. All right. And was that it?
Would you like me to prepare the proposed order for travel?
You can. What was it about the referral to sobriety court?
So I heard that what went in. I wasn't sure. My memory. I remember you speaking to the probation officer about her eligibility for sobriety court, and I wasn't certain if she had also put in a referral yet. Wanted to follow up.
I don't have a referral. Usually there's an intake done, but
Ron Brown, he had brought it and had made me sign it.
Sign it.
Next day I had her, so I wasn't sure if he gave it to her or submitted it at all.
He did not give me any.
He probably did not submit it if that's what happened. That's the timing of it. I can say this, certainly you can go through that, and I'm not going to have any objection. I don't have any problem with that. But the only issue is, did you take care of the other matter?
Yes.
So, she has appeared twice for Shelby Township. She has a court date for Clinton Township on the 20th. I went ahead.
That's the OWI.
Yes.
That's out there. So you're dealing with that.
Yes.
Okay.
My warrants have been handled. My warrants have been handled.
Okay. Yeah, I get that the warrants have been handled. I think the issue may be with sobriety court that you've got this other thing pending out there. Right. And they probably, I would think, I'm not going to speak for them, would probably like to see that resolved. And then this resolved as part of that whole thing. Okay. All right. Anything else?
Oh, thank you.
On continue. Thank you. All right. I realize everything.
By the conclusion of this hearing, Judge Simpson had resolved several procedural issues without making any determination on the underlying criminal charges. The discovery dispute remained open for formal written motions, giving the defense an opportunity to examine whether any legally significant problems existed in the collection, handling, or testing of the blood evidence. Importantly, the court did not presume that a defect existed simply because additional questions had been raised. Instead, Judge Simpson required the defense to identify a specific legal basis before allowing a routine discovery matter to develop into full-scale litigation. That approach reflects a fundamental principle of criminal procedure. Challenges must be supported by concrete facts, not speculation. The bond issues resulted in a different outcome. Rather than denying the defendant's request to travel, Judge Simpson approved it on the condition that she continued to comply with all existing bond requirements, maintained her alcohol monitoring, and remained actively engaged in her treatment program. This reflects a common judicial philosophy: Additional privileges are earned through consistent compliance and responsible behavior, not granted automatically. Throughout the hearing, Judge Simpson struck a careful balance between rehabilitation and accountability. He encouraged the defendant to continue making progress while making it clear that maintaining the court's trust was ultimately her responsibility. Perhaps the biggest takeaway from this case is that much of modern criminal procedure happens outside the dramatic courtroom moments often seen in the media. Discovery requests, treatment participation, bond conditions, monitoring technology, and strict procedural compliance can shape the outcome of a case long before a trial ever begins. The hearing also highlights an important lesson. Credibility is built through preparation, specific legal arguments, and consistent compliance with court orders, not through broad claims that lack support in the record. What do you think? If you were in Judge Simpson's position, would you have approved the defendant's request for interstate travel under these conditions? Or would you have imposed even stricter requirements before granting permission? If you enjoyed this courtroom breakdown, be sure to like the video, share your thoughts in the comments, and subscribe for more in-depth analyses of real courtroom proceedings and the legal decisions that shape them.